Okay, welcome to part 3 of the Brainwashing in Rail Worker Death Investigation Reports by the Transportation Safety Board uh, series. And in this particular video, we're going to be looking at how the actual report layout plays a huge role in brainwashing the readers of these reports. And if I haven't mentioned it, I have a master's in finance. So I definitely understand the financial implications of all of these issues as far as liabilities, etc. However, I've also done master's level technical writing, and that's what really helps me to pick out these issues that I've been sharing with rail families in all of these videos. And I've also had the opportunity to work with a lot of lawyers and excellent lawyers as far as also giving me experience in how to recognize these things. So my background, quite frankly, could not have been more perfect for doing what I call this rail worker death investigation dissection. Now, you're going to see this particular section on all the brainwashing videos because I need to keep everybody reminded as to the different documentation that fits into all of this. On the left, the Railway Safety Act. Then we have CTC Rail 3 or SOR 87-150, which is the Railway Employee Qualification Standards Regulation. And then the final document, TCO 0-102, the proposed new rules respecting minimum qualification standards for railway employees. So again, keep in mind, acts override regulations, regulations override rules, and all of these are used in, pulling information from one or the other or excluding the act, for example, completely from Jason's accident reports in order to give the proper effect that the Transportation Safety Board, Transport Canada, the rail carriers, whatever, want to give as they brainwash the public and all rail families, whether or not you are a frontline rail family, you are a investor as far as investing in rail carriers, whether or not you're a rail customer. There are many, many rail families that are impacted by all of these issues. And so, again, acts override regulations, regulations override rules, and then there's also guidelines, policies, whatever. Acts and regulations, definitely enforceable in court. The others may not be. So keep all that in mind as we continue to go through these brainwashing videos. Okay, if you recall on the last video, part 2, we ended on page 12, where we went through what were the requirements as far as the training program, and we discussed this part here on the trainee. Next comes this thing on mental model and situational awareness among operating crews. Okay, more disclosure. I have a master's in finance. But before I went back into finance and did an undergrad in finance and then a master's, my first area of interest was going into psychology and business writing, technical writing. And so I studied psychology and technical writing at the undergraduate and also the master's level. And so again, they could not have fallen on a worse person than me to do this dissection of a rail worker death investigation because I seem to have all of the background that I need to have in order to expose all of these issues. And one of those backgrounds is absolutely having done coursework in industrial psychology, which looks at these things like mental models and situational awareness. So I know exactly what these issues are about. But what I want to show you here is that we went from regulatory type stuff and program requirements, etc. Now we're going into psychological stuff, trying to make it look like the trainee who was killed had a bad situational awareness as far as what was going on at the time that he was killed and what he was focusing on, etc. On that note, I'm going to be skipping this section right now because the purpose of this video is to show you how the layout itself helps with brainwashing. And the point I want to make in this video is that from page 12, we then move into this psychological discussion and other discussions, and then we get back into discussions pertaining to regulations, etc., and training. And so by splitting the conversations in a report, are you going to remember what you read? You know, on page 10 or 11, those special footnotes, those special made to fit definitions. Are you going to remember the regulations, etc.? Maybe not, because you're focusing on reading what's in front of you at this time, and it's a completely different type of analysis. We're going into completely psychological stuff here. And then we're going to get into the technical stuff tied to derails. And then we get back into requirements as far as regulations and whatever. And so by splitting the conversation and the physical layout of the report discussions, that's another way to help with brainwashing. And that's the point I want to provide here. Okay, so on page 13 here, we have at the top where I'm Xing it out, that's the continuation of the situational awareness discussion. So we go from a psychological, a legal discussion as far as the regulations, and then we get into the training programs, and then we go into this psychological discussion on situational awareness. Then we skip into another discussion on manual derails. Because this particular trainee was killed while he was installing a derail, which is a unit that gets installed on tracks in order to derail a train on purpose. This was a siding, and so because they had left some rail cars on this siding, in order not to have rail cars accidentally roll from a siding back onto a main track, they install this unit called the derail. And so if the cars start moving for any reason, they will automatically get derailed before they hit the main track. And so this worker was installing a derail in order to secure those rail cars onto that siding. So anyways, so we go from the training program conversation, then to the situational awareness or very psychologically intensive conversation. Then we get into a more technical conversation on derails. And note here, another thing that they do is the first two pictures on page 14 are diagrams. So you might, do you spend a lot of time looking at that, or are you going to spend more time looking at the actual picture? Perhaps not even knowing what you're really looking at, but it changes your focus back and forth is the point, and that too helps with brainwashing. Okay, before we leave page 16, I've removed the X here on the little section called analysis, because I want you to notice this, what I call the setup. So we discuss regulations, and then we discuss training programs, then we discuss, situational analysis, which is very psychological as far as what that involves. Then we get into derails. So that is all part of the setup for what this section is that they now call the analysis. So you need to see how this all works together, and look at what they're going to tell you now that they're going to focus on. So it says, no track or equipment deficiencies were found to have contributed to the accident. The analysis will focus on situational awareness, the application of operating rules/instructions without adequate supervision, conductor training, the manual operation of derails, and regulatory overview. Okay. So again, they're saying what they're going to focus on. The situational awareness, by the way, they try and make it look like this guy was totally basically distracted. That's a big assumption. They don't know what this guy was thinking. So the whole situational analysis is quite frankly a complete and total assumption on the part of the people writing this report. Not, well, it's an assumption, but it's also a deception in how it's being used in this report, in my humble opinion. Because you're going to see that there's a lot of stuff that is left out of this report, and how those things that are left out of the report also would have impacted this trainee's situational awareness. But we're not going to discuss that in this report. We're just going to give the story that we want to give you and leave critical facts out. We're going to get into the critical facts that are left out in other videos. So they want to focus here on situational analysis, application of operating rules and instructions. Why are they not focusing on requirements under the Railway Safety Act and the Railway Employee Qualification Standards Regulation? Oh, we don't want to focus on that because that would show that CN was very likely violating a whole lot of laws when conductor trainee Jason Clooney was killed. So then they're gonna, instructions without adequate supervision. Absolutely an issue, yes. They're saying they're gonna focus on conductor training and the manual operation of derails. The fact that he was operating a derail, or that he was installing one, is really not what killed them. The lack of supervision, I would argue, is a much bigger issue, as is the fact that the supervising conductor, according to the Occupational Health and Safety Tribunal of Canada hearing pertaining to this death, the supervising conductor was never trained in how to supervise a trainee. And we don't want to get into those discussions here because those never happened prior to this report being written, right? Then they're also going to be discussing a regulatory overview, and we'll get into that, but it's certainly not what it needs to be, because again, when you ignore the Railway Safety Act and the requirements of the Railway Safety Act, the requirement of the labor code, the requirements of the need to have safety management systems in place, all kinds of requirements. When those are missing and not even discussed in this report, that's a huge issue. Okay, before I leave this little section here on page 16 pertaining to the analysis and the accident, I took out one of the red bars here, the red lines for the X, because I want you to notice one other thing here real quick. There's only references as they discuss the accident. They're talking about track switch 23, TS23, and they talk about track switch 22. And there was also a track switch 21 at this location, but pay particular attention to the fact that we're discussing TS22, TS23. My point here, when I was saying that they're missing information in that warps this whole analysis, is the fact that this switch, the deadly switch that was reversed by accident, was labeled TS23 on the switch itself. But in all the witness statements, in discussions, the 3 other crew members that day referred to TS23 in their discussions, not as TS23, but as TS15. And so it appears that the documentation tied to that site, that work location, may not have matched the actual switch designation. And remember, this was a trainee working in the dark in unfamiliar territory. And I also have reason to believe that the other switches, TS22, TS21, may have also had other designations in the work instructions provided to the trainee. So basically what I'm saying is that the trainee may have been looking for a switch number to reverse when it didn't match the documentation he had been provided for that work location. So if I'm looking for TS15 and the switches are labeled TS23 and maybe TS22 is labeled something else too, can you see maybe that there would have been confusion and maybe that would have helped increase accidents? I'm going to show you the actual documentation from the witness statements, but that's why I want to skip over the accident section right now, but I am going to be discussing this and providing you the documentation to prove to you what I'm saying, because that comes from the actual witness statements, which the Transportation Safety Board would have absolutely have had access to. And so there is no reason for the whole discussion on TS15 to be missing from this accident report, because where would these people have gotten this information, TS15? We're going to get into all of that and how it affects situational awareness and all of these issues. So what's in the report is one thing. What is left out is a whole other thing as far as how the brainwashing and the deception also happens in these reports. Okay, so the top of page 17 here, as we keep going, is again discussing the accident. And you can see again here how they're talking about TS22 and TS23. You don't see TS15 anywhere in this document. Keep that in mind as we go ahead in other videos. The next discussion here is where we're getting into the supervision of Canadian National Railway conductor trainees. And in the middle here, I want you to remember the Transportation Safety Board made to fit definition, which was found in a footnote in Jason's accident report on page 11. And the critical part here, and again, are you going to remember what you read on page 11 in a footnote, if you even read the footnote? When now we're on to page 17. So this made to fit definition. An on-the-job trainer is an experienced employee who is designated by the company to provide assignments and trainers for a trainee. Does that sound like an on-the-job trainer? No, that definition is nowhere else to be found in documents that I looked at as far as the Railway Safety Act, the regulations, etc. This is a made-to-fit definition that basically describes the role of a manager, not of an actual on-the-job trainer. So the fact is, the actual on-the-job trainer is the supervising conductor. He's the one providing the training in the field. The OJT, as they also refer to them, that's a totally separate person. These are two people, but the way the report is written, we're made to believe they're one and the same, and they're not. The supervising conductor is a different person. So look at how this next paragraph is written as we do the switcheroo for the supervising conductor and the on-the-job trainer. Okay, so it says, while the current regulations require that a railway employee training programs for each, they require a training program for each occupational category, they require only on-the-job training for the duration of the training period for the locomotive engineer and the transfer hostler. Well, wait a minute. If you remember in a previous video, and that's why I keep telling people, it's so important that you look at these videos in sequence. You can't be skipping from one to the other because they build on one another. But if you remember when we had the Mackyard incident, in that 2007 incident, when the report was generated, that incident had shown the many problems with fake qualifications basically in the rail industry, that trainees were not getting the training they were supposed to get. And so then Minister of Transportation John Baird issued a Section 19 order under the Railway Safety Act telling all Class 1 rail carriers to overhaul their training programs. But when that report was written, it was R07T0270. In that report, I think it was on page 11, 10 or 11, there was table 1. And table 1 was a summary of the current training program. And so in that, if you recall in the previous videos, I had pointed to the fact that under the current training program that was supposedly on file with Transport Canada, there was supposed to be an experienced conductor for the trainee for the duration of the training programs for the as far as the 45 field trips. Maybe not for the classroom instruction. They didn't need to be the same supervising conductor, but or supervisor. You could have one person teaching the classroom stuff, but the person who was providing the field training, per the information that was on file with Transport Canada, it was supposed to be one trainer for the duration of all those 45 trips. And so unless CN had properly filed changes with Transport Canada to have that change so that several trainers could train a trainee during that duration of those 45 trips, then that training program change, if it was not approved by Transport Canada first, and given the fact that that issue is discussed as a change, I believe on pages 11 and 12 of this particular report, or no, page 10 of this report, that would tend to indicate that those changes had not been filed with Transport Canada, because the implication, again, they tried to make you believe that per the regulation, we only need to give a description of the change to Transport Canada 90 days within 90 days after implementation in the field, when the regulation makes it look like you only need to file changes after the fact, but the overriding Railway Safety Act, which overrides the regulation, says no, per section 18 and 19, those changes must first be filed with Transport Canada and approved prior to field implementation. So they're trying to tell you here that there is no requirement for the trainer to stay with the trainee, that it's a one-to-one relationship for the duration of the training program. That is not what appears to have been stated in R07T0270. And to get to the issues, lawyers would have to see what updates had been provided to Transport Canada for approval, what changes to training programs had been provided to Transport Canada for approval prior to field implementation. So this whole section here, where it says, unlike the case of a locomotive engineer and transfer hustler, there's no regulatory requirement for a conductor trainee to work under the direction of or remain in close proximity to an on-the-job training instructor. That would be wrong given this bottom section here, which says, no railway company shall permit an employee to work as a locomotive engineer, transfer hostler, conductor, or yard foreman unless the employee has qualified for that occupational category in accordance to section 14, which provides all the different subjects they must be qualified in. So a trainee by definition is not qualified, so they must work under the supervision of someone, or else to allow a trainee to work alone, unsupervised, would mean that the company is violating section 5 of the Railway Employee Qualification Standards regulation. And again, a regulation is enforceable in court. But what they do here in this first paragraph, under the supervision of Canadian National Railway conductor trainees, by adding the end of this sentence here, unlike in the case of the locomotive engineer and transfer hustlers, there's no regulatory requirement for a conductor trainee to work under the direction of or remain in close proximity to an on-the-job training instructor. Here's the key: for the duration of the training period. So here's what's happening. they take the words, there's no requirement for them to remain in close proximity to an on-the-job training instructor. Well, the on-the-job training instructor here is referring to the made-to-fit definition, that this is an experienced employee who's designated by the company to provide assignments and trainers for the trainee. So it's a manager. This is describing a manager, this made-to-fit definition. So they're slipping in this on-the-job trainer, okay, in this paragraph here, an on-the-job training instructor for the duration of the training period. So yeah, this is a manager. It's not a union employee who is the supervising conductor. So they did a switcheroo here by inserting the made-to-fit definition in this paragraph. So there's no requirement for the trainee to stay next to the on-the-job training instructor or the OJT who never goes on training field trips anyway. So of course there's no requirement for them to stay close one next to the other because the OJT is never on these trips to begin with. So it's a complete deception and outright lying to people reading this report. Okay? And again, you have to compare this to table 1 in R07T0270 and see what were the requirements of the training program that appeared to have been on file with Transport Canada. And again, I requested a copy of all changes approved by Transport Canada since that railway investigation report and the Mackyard incident of 2007, and they provided nothing. And the information provided by the health and safety officer in his report, the health and safety officer worked for Transport Canada, and in his report, as opposed to working for the Transportation Safety Board. So the health and safety officer also wrote a report, not this one, a completely separate report. That one is 80 pages long. And in his report, he says that the information he was provided as far as training programs appeared to be rather out of date. And we're talking seriously out of date. But anyways, so you need to notice here the switcheroo where they put this on-the-job trainer made-to-fit definition and they inserted it into this paragraph so that, it's a total deception of the reader. Then the next sentence, consequently, conductor trainees will sometimes perform the duties of a regular crew member without direct supervision. The direct supervision in the field does not come from the on-the-job trainer as defined in the made-to-fit definition. The supervision, the direct supervision comes from the supervising conductor, which is a completely different person. That's a union employee, not a manager. So, and to even put this in here, consequently, conductor trainees will sometimes perform the duties of a regular crew member without direct supervision. That would be a complete violation of what's on the lower right here as far as the Railway Employee Qualification Standards Regulation, enforceable in court, Section 5.1, saying that they're not allowed to allow a trainee to basically work alone in an occupational category for which he has not been qualified, because trainees, by definition, have not been qualified. Okay, so then this whole thing about, let's see, such performance can be challenging for a trainee who in many cases is still learning the proper application of operating rules and instructions while becoming familiar in new territory. Okay, well, again, they want you to focus on operating rules rather than focusing on the fact that there's regulations and acts that override operating rules. Okay, so just be very, very aware of things like this when it comes to brainwashing. The switcheroo of a definition and then continuing on in the paragraph discussing the supervising conductor, who is a completely different person. So they're discussing two people in this paragraph, making it look like they're one and the same. That's the point here. Okay, if you look here then at the next arrow here where it joins above my head, the left and the right, um, it says, while the present conductor training program at CN Railway has an on-the-job training component under the guidance of a trainer, there is no regulatory requirement and no company guidance or instructions provided requiring a trainer to remain in close proximity to a trainee. Okay, well, which trainer are we talking about here? Are they doing the switcheroo again, meaning that this is the on-the-job trainer from the made to fit definition, the OJT, who is a manager? The person, are they talking about the person here providing the classroom training? Because that could be a manager. It could be an OJT providing that particular component as far as the training, but it could be the class training. So the thing is, if they are trying to say, see, they're using the word on the job training component. So under the guidance of a trainer. So that would imply an on the job trainer. But to say there is no regulatory requirement and no company guidance is irrelevant. What matters is the law, either the Railway Safety Act or the SOR 87-150 Railway Employee Qualification Standards Regulation, which is provided on the lower right here, as far as not allowing trainees to basically work alone because they haven't been qualified to work alone. So if they're talking about the classroom person here, that, CN has an on the job training component under the guidance of a trainer, again, are we talking about the OJT as defined in the made to fit definition on page 11? Or are we talking, because if we are, then to say there's no regulatory requirement and no company guidance or instruction requiring a trainer to remain in close proximity to a trainee, that would be true. But that's because this is the OJT as defined in that footnote is a manager. It's not the supervising conductor, the real on the job trainer providing the training in the field. So note here, then they switch over to the words when a conductor. They're not saying when an on-the-job trainer works in close proximity to the trainee. Now they switched over to the word conductor. When a conductor works in close proximity to the trainee, there are additional opportunities to observe and correct any switching errors. Yeah, of course, but that's only if the conductor's been trained in how to supervise the trainee. And in this case, the conductor had not been trained. And if this conductor was never trained in how to supervise a trainee, the odds are probably no conductor at CN has been trained in how to supervise a trainee, because there does not appear to be a training program specific for supervising trainees. And I can attest to that because my own child was a conductor trainee, then became a conductor who was supervising trainees in the field, having undergone no specific training program in how to supervise a trainee. So again, are we doing a switcheroo here in this paragraph using the on-the-job training component to refer to this made to fit definition on page 11, which you most likely would not even have remembered reading by the time you get to page 17. And the other issue too, the average person reading these reports, unless they're tied to the rail industry somehow as a family member, they would have no idea that there's a difference between the on-the-job trainer and the supervising conductor necessarily. You have to understand how the industry works, the different terms like OJT versus a supervising conductor, what has qualified means. You have to have a basic understanding of the rail industry in order to pick all of this stuff up, or else there's no way you could figure it out, really. So there's that point too. But note that we go here from an OJT basically to a conductor. Why isn't, if they're talking about an on-the-job trainer and it's only one person, why not use the word the on-the-job trainer throughout this document? Why do we switch back and forth between the on-the-job trainer and the conductor as if they are one and the same, and that's done in the same paragraph from one sentence right into the other? So again, part of the brainwashing. And unless you understand these issues, you would be no wiser to them and how you're being brainwashed via these reports. So it's let's see. It says in this occurrence, the inadvertent reversal of switch TS23 was not identified. Again, why does that not say TS15? Because that's how the other three crew members referred to this switch, TS15, not TS23. And we're going to get into that. That it says, if conductor trainees work independently, which would be against the regulation enforceable in court. So they're basically telling you here, CN was violating the law. If conductor trainees work alone, you're violating the law. Without direct supervision in close proximity, there is an increased risk of error, which can result in an accident. Notice here, part of the brainwashing, it's an if, not a when. If a conductor trainee works independently, because it's just an if. We're not assigning blame. It's not a when. And they're not, again, referring to the violation here of SOR 87-150, Section 5. Why is there no mention of that regulation right here in this paragraph? Why doesn't it say, if conductor trainees work independently in violation of SOR 87-150, Section 5(1)(a), again, why is that missing? Because, we don't want to assign blame, and we don't want to look like we're partial to one side or the other in these reports, right? I mean, we're only presenting the facts at the Transportation Safety Board when we write these reports, right? I think you can see, having gone through these videos, that these reports, in my opinion, like this report in particular, which is one which would show all of the problems with the training programs because it involved a conductor trainee. But you can pretty well see that there's a whole lot of lying and inaccuracies in these reports, and that's all done on purpose. Why are you only discussing things that are a violation of a rule when it's the trainee that you're discussing? Why are you not discussing the violation of a regulation here or of an act? Because trainees, unless CN Rail filed a change in training programs with Transport Canada and had that approved to allow trainees to work alone, they would have been in violation of the Railway Safety Act and SOR 87-150, Section 5(1)(a). So, but there's no mention of that in this paragraph, right? Both the act and the regulation are completely ignored. Now, in the last two paragraphs, they just talk about Jason's had 57 road trips. He had, and here, note here, but he did not yet have enough yard trips to complete the training. That makes it look like he had yard trips, whereas the witness statement taken over 200 days later by the OJT, which is a different person than the supervising conductor. Why was his statement taken over 200 days after this incident, after this death? That was to help provide the story du jour, as we decided to use two different people interchangeably in this report. But here's the thing. When they say he did not yet have enough yard trips to complete the training, well, wait a minute. Jason had 0 yard trips per the witness statement of the OJT. So, and would not the Transportation Safety Board have asked how many yard trips he had in their quote unquote investigation? They would have known he had zero if they had asked that question. And they had to have asked that question because they make the statement he did not yet have enough yard trips to complete the training. So they knew he had zero yard trips. Why did they not say the trainee had completed 57 road trips but had zero yard trips or yard training? The yard training is where you would get a heck of a lot of direct supervision of what's called PMRC, procedures monitoring for regulatory compliance. So that would have been the radio communications, would have been overheard by people listening in to make sure his radio communications were right. That's where you most likely would have had that one-on-one, very direct, according to the law, supervision, because in a yard you're working with a lot more switches than you usually are on the road trips on the line. And so, you know, again, why all this deception? He had zero yard trips. And so, and the few evaluations that he did have, well, he was missing 25% of his evaluations or so, but the evaluations did show that he had problems with switching activities and with working independently. And so, again, why would you have allowed this trainee to walk off in the dark by himself when CN knew he had problems working independently and with switching activities? And you allow him to walk off in the dark doing switching activities. He flips the wrong switch, which appears to have been mislabeled according to the track switch 15 versus track switch 23 information that is provided in witness statements. He flips the wrong switch. Nobody is there to correct that. And so the movement goes from the main track back onto the siding where he's got his back to the oncoming movement and he gets killed. Okay, again here, when they're describing Canadian National Railway's Accelerated Conductor Training Program, again, until 1995, which is when CN went from being a crown corporation of the Government of Canada to being one that now had stakeholders. It was a publicly traded company, so we're now accountable to stakeholders. We went from a 2-year program to one that could basically be finished in 17 weeks. So that's a huge issue. Then here the next section says the Transportation Safety Board reviewed CN's conductor training program and identified the following issues relevant to this occurrence. Now, would these be issues if these had been approved by Transport Canada? Very likely not. Why would it be an issue if it's been approved by the regulators? So very likely none of these things were approved by Transport Canada. Just my opinion based on what I've seen and what I've requested and received in matters pertaining to this death. So let's see. The first point, in some cases, newly qualified conductors are permitted to train new hires without significant experience working with the Canadian Rail operating rules in the field. A trainer may not readily identify an unsafe work practice or error. Why does that not also say without, proper knowledge of the railway employee qualification standards regulation and adherence to that regulation? Why are we only discussing rules is what I'm saying here. Why are we totally ignoring the violation of regulations and acts which are enforceable in court? You're not seeing that here. We're only focusing on rail operating rules, as we were told we would be focusing on in that first section on what the analysis would focus on. We're focusing on rules, not on regulations or acts that have been violated. Keep that in mind, part of the brainwashing. Then the second one, on-the-job training is administered by a number of different trainers without the requirement for the review of the trainer's previous evaluations. That's because there was never supposed to be that requirement, because you were supposed to have the one-on-one field training. It was supposed to be, according to, the table 1, again in R07 T0270, which appears to have been one of the latest or last things filed with Transport Canada as far as the training program. Um, and the reason I say that is because even though the Section 19 order, which was issued in R07T0270, resulted in that bogus document known as the Rules Respecting Minimum Qualification Standards for Railway Employees, which was created by the Railway Association of Canada and approved by Transport Canada in June of 2009. Well, that never went into effect. It was because the regulation was never repealed. SOR 87-150, again, was never repealed. And so the new rules or training programs would never have gone into effect. So even if they had been filed with Transport Canada, they never went into effect. And so the old remained. And from everything that I've been given, from what I requested, it does not appear that the rail carriers have been filing on an annual basis, changes to their training programs as it appears the law required. So, again, point 1 here, the bullet point 1, newly qualified conductors. Again, my child, basically the day after they were qualified, they were being asked to act as supervising conductors for even more junior conductor trainees when they themselves were still on probation and subject to dismissal for being unfit for this job for a period of 6 months. So the program was supposed to be that an experienced conductor would provide in the field training, not newly qualified conductors like my child. So again, the on-the-job training program had several trainers when they appeared to have required by law only one, per what was on file with the Minister of Transportation, according to that table 1. Then the company guidance or instruction provided does not require a trainer to remain in close proximity to the trainee. Again, company guidance or instruction is irrelevant. What does the law say? Why is this paragraph even in there? It's irrelevant. Why does this not say when SOR 87-150 section 5(1)A is violated, there can be an increase in accidents or deaths? Company guidance, irrelevant, completely irrelevant. Doesn't matter. Then the last paragraph here, the last bullet point, conductor trainees do not have to be familiar with the territory before working without direct supervision. Well, that again, okay, it's provided as an issue. Well, that would be a violation of the Canadian Rail operating rules under the general section point X or 10, which says they must be familiar with the territory. So why would the Transportation Safety Board say that conductor trainees do not need to be familiar with the territory before working without direct supervision, although this appears to be a violation of Canadian Rail Operating Rules General Section X or 10? You're not told that this is a violation of a rule. In none of these cases are we told that there's a violation of a rule or a regulation or an act. It's just, in some cases or whatever. Look at how this is written. And again, look at the bottom here. If there is reduced training period, an absence of direct supervision, and lack of continuity and assessment among trainers, it's an if. It's not a when clearly it should have been a when, because there is no question that this was a when in the case of the death of conductor trainee Jason Clooney. But the Transportation Safety Board doesn't want to assign blame. They just present the facts, right? Well, I would have added another paragraph here, and it would have been, if the Transportation Safety Board writes bogus reports pertaining to the death of rail workers, and if Transport Canada fails to do its job as a supervisor and enforcer of the regulation and act for potentially decades, then there is definitely an increased risk of railway worker or public injury or death. I would have added that paragraph in as a big if, right? Actually, I would have written it as a when, because the facts in these cases, folks, definitely seem to show a when. So, then I'm going to skip over this potential hazard when manually operated hinge derails section, because again, the layout here is we're shifting conversations, shifting your focus from one thing to another in order to confuse, make you forget what you read, make you forget rules, regulations. Most people would not even know the proper regulations and the acts, because people don't go and read the regulation and the acts before they read a railway investigation report. Most people don't know those things. So again, I'm going to skip over this section and then pick up the conversation later in another video when it comes to derails. Okay, so I'm going to end part 3 on brainwashing here. And again, so I just want you to know here how the layout of the investigation reports also helps with the story du jour, or the brainwashing that the Transportation Safety Board and or its rail PICs, Rail Partners in Crime, want to accomplish. And to those who take offense with my acronym rail PICs, which means Rail Partners in Crime for me, breach of public trust is a crime for which you can go to jail. And so is financial fraud. And the fact that these reports are written the way they are, they're signed off on by not only Transport Canada, but also by the rail carrier. So all these lies were clearly approved as being accurate by the rail carrier who had the opportunity to review this report. And in this case, that would have been the CEO of CN Rail at the time, Claude Mongeau, who is now at Norfolk Southern. Can you say East Palestine Derailment in Ohio? Claude Mongeau is chairman of the board at Norfolk Southern. So, and there's a lot of other players from CN that have been allowed to escape accountability, in my opinion. And we're gonna get into that issue too in another video. But unfortunately, folks, I think that these videos are showing that you must question absolutely everything, because if you went through like I did and you red inked the report, you would see that it's nothing but a bogus report. It's a pack of lies or deceptions, and there's no other way to put it. So like, share, and subscribe. And if you are subscribed, make sure you don't get unsubscribed, because there's so many people who just would not want you to have this information or share it with anyone else. But rail families, you need to be aware of these issues. And I'm talking all rail families, not just frontline rail workers. I'm talking unions. I'm talking rail investors. I'm talking rail customers. There are a lot of rail families that are impacted by all of these issues. Do you think that a person, a company would actually, like a big pension fund, a big equity firm, would actually invest in companies like CN Rail, or invest in the government of Canada and its treasuries or debt instruments or whatever, if they knew what is now being disclosed via these videos? As an MA in finance, I can't tell you enough. There's nothing that makes investors run like an ugly scandal. There's nothing that tanks stock markets prices more than ugly scandals. And this one is definitely one for the books. So again, like, share, and subscribe, and make sure you remain subscribed. And on that, have a good day, and I will see you in part 4.